Hello everyone, this is Wood on Peers, and I think that the King striking Prince Andrew, Duke of York, off the roll of the peerage might have massive implications for the House of Lords and its ability to hold governments to account. I think, I'm not certain, but I think there's a serious possibility that the government or any government has gained an enormous amount of power as a result of this act. To give the background, without going into too much history, since the 17th century, peerage titles, which from that time on was solely about membership of the House of Lords, were made impossible to give away or to surrender back to the king. I will also say it was possible for you to have your titles forfeit if you were convicted of treason, but this was abolished in 1870 by the Forfeiture Act. Now, the only way that titles can be removed is through primary legislation, through an Act of Parliament, and we saw this in 1917 with the Titles Deprivation Act. That is the last instance of trying to remove someone's title. Just to clarify, this is not about Prince Andrew, or formerly Prince Andrew. This is not about the princely status. Princely status is defined entirely at the monarch's will, and it is governed by royal warrants, which can be issued at any time. I should just say, I'm not talking about his being a prince or not. That's effectively irrelevant for this purpose, because being a prince doesn't get you membership of the House of Lords or anything like that. What this has to do with is Charles ordering Andrew, Duke of York, to be struck from the roll of the peerage. And this is about his peerage titles, Duke of York, Earl of Inverness, Baron Killyleagh. I will talk you through why I think this could be huge. Hereditary peers had a right of membership of the House of Lords until 1999, when this is removed by the House of Lords Act. It used to be an automatic membership, although now there are representatives of the hereditary peerage that are by-elected to a certain number of seats. So, anyway, but I'll get onto that a bit later. Life peers, the other kind of peerage, have always had the right of being summoned to the House of Lords since the passing of the Life Peerages Act 1958. Now, I will go into the history a little bit. The reason this had to be done by statute is because there was an earlier attempt to create life peerages using just the royal prerogative, but the House of Lords decided that a royal prerogative life peer would not have a right of a summons to the Lords. So it had to be done through statute. Now, the Clerk of the Parliaments used to keep a list of members of the House of Lords, and this was the roll of the Lords spiritual and temporal. Makes sense. This included all members of the Lords, so all the life peers and most of the hereditary peers. Peers of Ireland didn't have an automatic membership, and they were on effectively a separate list, but I'm not going into that. After the hereditary peers, or most of them, had been excluded, they were not kept track of on that roll. So to remedy this, another royal warrant was issued in 2004. This royal warrant stated that it is desirable for a full record to be kept of all of our subjects who are peers. This has set up the roll of the peerage. It was based on the roll of the baronetage, but again, there's always tangents to go down. According to, I guess it's section 3 of the royal warrant, and I quote, "Any peer who is not entered on the roll shall not, according to section B, be addressed or referred to by any title attaching to his peerage in any civil or military commission, letters patent, or other official document." This is pretty significant. Letters patent are the documents that officially create titles. Interesting that they cannot be referred to by their own title in their own letters patent. This is starting to get on interesting ground. So Andrew had the title Duke of York. His title, as it happens, was a hereditary title. It wasn't made under the Life Peerages Act 1958. He had no statutory right to receive a writ of summons, although again I'll come back to that. He was kicked out of the Lords in 1999. with the exclusion of most of the hereditary peers. There's little practical effect for his being struck off the roll of the peerage. But what about a life peer? A life peer who is a member of the House of Lords today. Almost the entire membership of the House of Lords is comprised of life peers. I'm going to try and work this through. On paragraph 4 of the Royal Warrant establishing the role of the peers, states, the registrar shall enter on the roll all peers who are created after the date on which this our warrant is given. So when you're newly made a life peer, you're put on the roll. That's fine. But, and I want to be very clear about this, the King has been able to unilaterally remove the Duke of York from the roll of the peerage. The Gazette simply states, the King has been pleased by warrant under his Royal Sign Manual dated 30th of October 2025 to direct his Secretary of State to cause the Duke of York to be removed from the roll of the peerage with immediate effect. Now, all of this so far is being governed by royal warrants. A royal warrant set up the roll of the peerage, a royal warrant is removing Andrew. Okay, I mean, I suppose in a way there's no contradiction, because this royal warrant will supersede the other one. The Duke of York is now no longer on the roll of the peerage. Okay, but again, what if this were done to a life peer? The Prime Minister, after all, could recommend to the King to issue another royal warrant to remove any life peer from the roll of the peerage. This means they would not be able to be addressed by any title attaching to their peerage. Now, peers are issued writs of summons that invite them to attend the House of Lords. They're a document that says, essentially, directed to this person, you are summoned to Parliament. It's effectively what it says. And the writs of summons are in a standard form. In these writs, it is stated,
to our right trusty and well-beloved councillor, Leonard James Callaghan, of the city of Cardiff, in our county of South Glamorgan, Chevalier, greeting.
To whomever, comma, of wherever, comma, Chevalier, greeting. Chevalier, as a word, meaning knight, first appeared appended to 3 names on the list of writs of summons for January 1376. These 3 were William Morley, William Oldborough, and John Wells. There were a bunch of other people on these list, but only they were called Chevalier. As the years went on, it started to be used for a smattering of different people. Generally speaking, this is a distinction between people who were more recently summoned and people whose titles went back a longer way. When this distinction became irrelevant, from 1425, Chevalier was put after every name on this list of writs of summons. And it is, and I can quote Enoch Powell and Keith Wallace on this, page 372, quote, it continues to the present day to be the designation of a baron in his writ of summons. This is surely a title attaching to a peerage in an official document. Now, you could try and argue that a writ of summons is not an official document, but then I would refer you to the fact that the royal warrant explicitly mentions letters patent. Letters patent make a peerage. So either you can't be given a writ of summons in the usual form, and frankly, if you don't have a document in the usual form, I think it's pretty unlikely that it would have any effect. After all, the Lords has been extremely fastidious over the centuries in defending its privileges against the monarch. There is in fact a standing order that requests any difference between the form of a writ of summons nowadays, so I think this was 1620s, from how it used to be. If there's any difference in the form of a writ, this needs to be looked into. Not entirely sure what that would mean in this case, but generally speaking, you can't just change the structure of these documents at will. If we're talking about a writ of summons, I think that would become invalid. If we're talking about letters patent that create a peerage, then it sounds like the letters patent themselves would become invalid, because that's explicitly mentioned again in this royal warrant. And I will say it is possible for the king to vary the form of a writ of summons by powers conferred under the Crown Office Act 1877. And in fact, I think it was 1969, varied the form of a writ of summons of the Writ of Summons, I should say, for the Lords Spiritual. But again, this would have to go through both Houses of Parliament. You can see where I'm trying to get with this. But, hold on. A life peerage is a statutory power given to the monarch.
Know ye that we of our especial grace, certain knowledge and mere motion, in pursuance of the Life Peerages Act 1958, and of all other powers in that behalf us enabling, do, by these presents, advance, create, and prefer. Know ye that we of our especial grace, certain knowledge and mere motion, do by these presents advance, create, and prefer.
The Life Peerages Act 1958 states that a peerage for life, which, subject to being disqualified by law, entitles the peer to receive writs of summons to attend the House of Lords and sit and vote therein accordingly. Section 4 allows for disqualification by law. Interesting. Let's pick this apart a little bit. Firstly, what are the legal disqualifications for sitting in the House of Lords? Today, they are if you're a child, so under 21, if you're a foreigner, and this was tightened up in 2010 under the Constitutional Reform and Governance Act to be that if you are based for tax purposes outside of the UK, if you're a bankrupt, you can't sit. If you've retired from the House of Lords under the 2014 House of Lords Reform Act, and if you are suspended or expelled under the House of Lords (Suspension and Expulsion Act 2015. Although I've heard opinion said that it is possible to be suspended or expelled before this act by virtue of the inherent power of the House. Interesting. Also, if you're a sitting judge, you're disqualified from sitting in the House under the Constitutional Reform Act. And of course, if you're an hereditary peer that doesn't have a seat in the House, you're also disqualified from sitting in the House as a peer, because you're still a peer. It's just, there's no right anymore. It's only the accepted up to 92 who have that right. The current legal position, and of course this is being changed by the House of Lords Hereditary Peerages Bill, but the legal position is that there's a maximum of 92 seats for hereditary peers in the House of Lords, and you'll see where I'm going with this. Up to 90 of these seats are filled by by-elections. If you're an hereditary peer, and you want to, I'm quoting Erskine-May here, be included in the register of hereditary peers wishing to stand in a by-election, that's Erskine-May 11.6, you not only need to apply to the Lord Chancellor through the Crown Office for inclusion on the roll of the peerage, which Andrew's been struck from, but also on the register of hereditary peers wishing to stand in by-elections. Now, there are two lists here. We're talking about the roll of the peerage and the register of hereditaries wanting to stand. The roll of the peerage is, and I'm quoting Erskine-May, the authoritative list of the complete peerage and is evidence in cases of dispute. The separate list, the register of those wanting to stand, is authorised by standing orders of the House of Lords. I'd argue that if you're not on the roll of the peerage, that would legally prevent you from joining the register of those who want to stand, and therefore prevent you from standing for by-election, and therefore prevent you from sitting and voting in the House of Lords. I argue, therefore, that not being on the roll of the peerage is a legal disqualification that would trigger Section 4 of the Life Peerages Act, which provides that you're entitled to a writ of summons unless you are legally disqualified. I think that any answer to the question, well, it doesn't matter what form the writ of summons is in, because according to statute, whatever the form of the writ of summons, it will have the effect of summoning you to Parliament, I think is countered by this. Well, if you're not on the roll of the peers in the first place, then you can't legally prove you're a peer, or you haven't legally proven you're a peer. It's the effect of being struck off the roll. So feels like if you're not a peer, within a mechanism that is designed to regulate, to some extent, membership of the Lords by enabling hereditary peers to stand for by-election, sounds like you've lost your right to a writ of summons under the Life Peerages Act. Very clearly, the drafting of the Life Peerages Act states that you are entitled to receive a writ of summons and accordingly sit and vote. So the sitting and voting is totally dependent on receiving the writ of summons, which I don't think you could do if you were struck from the roll of the peerage. Now, it's possible, of course, for the House to determine its own membership. I imagine that a meeting of the Privileges and Procedure Committee might need to be convened. One thing I'm certain is that if this were tried, it would be extremely messy. But I just want to underline, Andrew, Duke of York, has not been found guilty of anything in any court. There's no legal reason for His Grace, as I suppose he now is, to be removed from the roll of the peerage. If Charles's removal of Andrew from the roll of the peerage is allowed to go through unchallenged, and it hasn't been challenged, and I mean, I don't really think there'd be any likelihood of that anyway, then it appears to me that it would be possible for any future Prime Minister, if the House of Lords or a certain number of peers in the House of Lords were being a pain, to recommend to the monarch to issue another royal warrant to strike any life peer off the roll of the peerage. And then, even if I'm sure they could judicially review this, they could probably under Miller II judicially review the advice given to the monarch. There are mechanisms in the royal warrant establishing the role of the peerage that, for applying to be put on it. You have to apply to the Lord Chancellor, or the Secretary of State rather. So I imagine that if the Lord Chancellor were against that, you could judicially review that refusal. So there are probably some ways out of this, but that would take more time than it would take Parliament to pass an act to exclude you, if you were a peer, from the Lords. So you see what I'm saying? You could remove any politician you don't like out of the House of Lords, and then follow it up with confirming that they're fully excluded by Act of Parliament. They couldn't appeal it. I mean, they can't appeal an Act of Parliament. They couldn't stop it from happening in the Lords because they're not there. It seems to me as though, and as I say, I may be wrong. Please, I'm more than happy to hear arguments against this. But it seems to me as though it is now possible, with the establishment of the role of the peerage and the precedent, as it were, of removing anyone you want for any reason from the role of the peerage, it seems possible for prime ministers now not only to stuff the Lords with new peers, as many as they want, but to remove any peer they don't like. Note, though, that this, I think, applies much more obviously to the hereditary peers. I'm still convinced it applies to the life peers under the Life Peerages Act. It would not, however, to my knowledge, apply to the law lords, the former law lords with life peerages under the Appellate Jurisdiction Act.
To our right trustee and well-beloved councillor, William Hugh Griffiths, a Lord of Appeal in Ordinary, greeting.
And it would not apply to the Lords Spiritual. All I'm saying is, if there were a political party that didn't have any members of the House of Lords, that was finding it extremely difficult to introduce enough peers, if they were to get into government, enough peers to get legislation through, if the House of Lords were not sticking with the Salisbury-Addison Convention, it seems like this could be a weapon up the sleeve of the Prime Minister to remove those peers for any reason he would want. Thank you very much for listening. Please let me know if I've got this totally wrong. I'm more than happy to have got this wrong. I think this is the case. Please let me know. I'm sure there's a lot of interesting discussion that can be had about the definition of a proceeding in Parliament, which has been very narrowly defined in Miller II, so that perhaps courts could get involved in the issue of writs of summons from the Crown Office. I wonder, maybe they could, maybe they couldn't. It seems as though judicially reviewing the royal prerogative has only been allowed if there's been advice given. So perhaps the argument could be, but there's no chance for advice to be given in this specific case. But in any future case, it would be the Prime Minister recommending this. So I'm saying I don't think this is totally cut and dry, but I think it's very interesting. And I'd be very happy to hear your thoughts. Thank you.